Hello, everyone. My name is Melissa Stevens, and I have my co-host Ellen with me. Today, we are going to be discussing procedural safeguards. I'm going to share my screen now. So again, procedural safeguards, which is the number 6 principle of the Super 6. This is our last training series, and it's again over procedural safeguards. Before the training begins, I would like to remind everyone to please keep your microphone muted unless speaking. To use the chat box, if you have any questions that may arise during the presentation or during me talking, you may put your question in and someone will be monitoring that to hopefully answer that question. But if not, we'll get to that question at the end of the presentation. Be mindful when sharing personal information. This training is being recorded, although during the question and answers, the recording will stop. We will also have a brief survey to help us make improvements. So please help us fill out that survey to help us learn what we can do later to make those improvements. So as I said, what are procedural safeguards? The Individuals with Disabilities Education Act of 2004, also known as IDEA 2004, provided methods known as procedural safeguards to ensure parent participation in the special education process and to ensure the student's right to a free, appropriate public education, which you may also hear as FAPE. Ellen, would you like to add anything to this area?
Good afternoon. IDEA's been around since 1975. It actually started out as the Education of All Handicapped Children's Act. And of course, we're now operating under IDEA 2004, but procedural safeguards or parent rights have always been part of the law. So we're just glad you're here with us to learn today.
Thank you, Ellen. So some examples of when you may need to use your procedural safeguard is parent participation. As we have discussed in our other training series, parent participation is affording you the equal opportunity and equal access to create, develop the IEP. So you should always have equal access to the IEP and to participating into designing that, giving suggestions, asking questions, your input. You are the expert of your child, so your participation throughout their IEP is important, and you have the right to participate. So in the event that the school is not allowing you to be an equal member of the IEP team, this is where you may have to invoke your procedural safeguard. Least restrictive environment. So under the IDEA 2004, it is also noted that students with disabilities should be in their least restrictive environment. So an example would be if the school is proposing to shorten your child's school day due to behaviors, or if the school has proposed to move your child or increase your child's time in their a more restrictive environment, then that would be where you'd be able to use your procedural safeguards to ask, this was a decision based upon the school's opinion and the school just wanting to propose this without your input. So again, if the school is not wanting to work with you and have that decision as a team decision versus just their decision, this is where you would have the right to use your procedural safeguards. Then assessment. So if you have noticed that your child is regressing in certain areas and that you would like an assessment done, or the assessment is not current, you would be able to request an assessment. And if the school is not wanting to do that assessment, you would be able to also then use a procedural safeguard to have that assessment either considered or have the assessment be an outside assessment where maybe the assessment the school did not show the areas that you suspect or impeding your child's education. Then there's conflict. So anytime that you are in a disagreement with the school, or there is just conflict within certain parties within the IEP team, and you have tried all the other avenues to, make that better, you're also then able to use a procedural safeguard, where if you need a third party to come in to help facilitate that relationship. These are all examples. There's many more of when you may need to use a procedural safeguard. Ellen, do you have anything to add on this area?
No, I mean, I think just making real clear that these are just examples of when you might, there's a whole plethora of reasons why you might need to use your procedural safeguards, from a small thing to a really big thing. And so the next couple of slides are going to talk about what some areas that you might want to look at, so, or you might have to look at.
Yes, thank you, Ellen. So today we are going to learn about access to educational records, procedural safeguards notice, prior written notice, understandable language, confidentiality of information, stay put rights, resolving a dispute. Under the resolving a dispute, these are three options that you have. Number one is mediation. Number two is filing a state complaint. And number three is due process. These are options. You do not have to go in the order of mediation, filing a state complaint, or due process. This is just the three options you have under resolving a dispute. You may choose either or. So the first is access to educational records. So again, the IDA 2004 states that parents have the right to request copies, to view, to receive any type of record that is in their child's cumulative file, which is the beginning of school to wherever they are at that point. You have the right to request a copy. You may have to pay a small fee if you're wanting copies made, but you do have the right to have copies made. You do have the right to receive, or just to go and view the file, or have an explanation of something. The procedural safeguards notice, also known as parents' rights. So the school district must provide the parent rights or procedural safeguards notice to you during an initial IEP meeting or the annual IEP meeting, upon request, or if you have filed a due process, which is one of your resolving dispute options. Those are the instances where the school must provide you the parent rights or procedural safeguards notice. The prior written notice. This is probably one of the most important safeguards that you have as a parent. The school district must provide parents a written notice anytime they are proposing or refusing to take action. So this would also include notifying parents of upcoming meetings that are mutually agreed upon. But I want to go back to just the actual notice. So an example would be, if you as a parent is, requesting the school to either increase your child's related service time for OT or speech, and the school tells you no, you have the right to receive that in a prior written notice, meaning the school has to detail why they either are agreeing or disagreeing to that request, or what they are proposing. They have to also give you an explanation of why they made that decision, any other factors that help them come to that decision. The prior written notice is something that I encourage parents, and we at OPC encourage parents to always receive a copy of. When you make a request and the school says no, if you make the request verbally, please make sure, if the school tells you the answer verbally, that you ask for that prior written notice, asking for them to include exactly what they said to you. This is an important piece of your procedural safeguards, and probably one of the most, I would say, underrated components of it that we sometimes as parents forget to ask for. So know that anytime the school is proposing or refusing something, they have to give this to you in a prior written notice. And please keep all of those notices in an IEP binder, file, or whatever that may be. And then the meeting aspect of it is that anytime the school is wanting to have an IEP meeting, the school has to make sure that it also, fits your schedule and that it's not just their schedule. They have to also give you ample notice so that way you can make sure that you have the time, the date, all works for everyone within the IEP team. So again, it's mutually agreed upon. Ellen, is there anything that I may have left out on this area?
I don't believe so, Melissa. I think just helping families understand that even though this is a required component of IDEA, that sometimes districts don't always voluntarily provide this to you. So I think really making sure that you do ask for it. And regardless if it's something you've requested and they're refusing, even if it's something they're proposing, they need to put that in writing for you. So.
Yes, thank you, Ellen. So understandable language. The school district must provide written notice in understandable language to the general public, but also to your native language or any other mode of communication. So if your first language is Spanish, they must provide this written notice or anything else in your native language or any other mode of communication that's used by you, the parent. Confidentiality of information. The school district must protect the student's confidentiality. This would include their name, address, social security number, date of birth. This is all information that is not to be shared, only be shared within the school or whoever that instructional team member, whoever may need this information, but this is information that is not to be shared outside of the people that need to know that. Stay put rights. So this provision allows the student to stay in their current placement if the parent and school district are in the middle of resolving a due process. So for instance, I had to use this for my own child at one time when the school was proposing to change his placement. I had to file the due process, and while we was going through the due process, he was able to stay in his same environment. There was no changes to his schedule. So this is something that I would encourage parents to know, that you have this option. If you and the school are at a disagreement and they're proposing something that you do not agree with, you have the right then to file this, or either, you do not have to follow due process, but in the middle of filing or not filing anything, the school may propose this change of placement. And even though there should be an IEP meeting agreeing to that change of placement, the school may change the placement. So this is one sure way that the school cannot move the child. The school cannot do anything different until the dispute is resolved via due process. So here are the options we discussed or we talked about earlier. The first is mediation. This is a free and voluntary process where the parent and school district can discuss their differences and try to reach an agreement with a skilled and impartial mediator. So this is a really good option if you and the school are just at a disagreement, not able to come to an agreement on whatever that may be within the child's IEP. Again, this is free, a voluntary process, and you in Oklahoma, you would contact the Special Education Resolution Center if this is the option you would like to go. Ellen, is there anything additional that we could add here that you may?
Just that mediation, keep in mind, if you are going to choose mediation as an option to resolve a dispute, that when you're resolving it through a mediation, you do have to come to the table with an open mind. Both parties need to come to the table with an open mind to collectively work together. And then if an agreement is reached, pardon me, then it is a legal binding agreement and must be adhered to through the process. So,
thank you, Ellen. The next option you have is a state complaint. So this would be a formal letter or a completed state complaint form that would be sent to the Oklahoma State Department of Education, Special Education Services, to report the violation of the IDEA. The decision-making in this particular option is the OSDE, or Oklahoma State Department of Education, Special Education Services. They would be the decision-making power if you went this route. Due process. So again, when we talked about the stay put rights, stay put is actually, what will happen if you file a due process. So this is where, let's say, mediation and state complaint is just, you have tried those routes and maybe at this point you want to just file due process. So this is where the parent or school district must write the written complaint to begin the process. The parent and school district will attend a due processing hearing that is like a courtroom trial. Either parties may represent themselves or have an attorney. So the school may have an attorney and you may either seek out an attorney or you may want to represent yourself. So again, this is a process that's more like a courtroom hearing. During the due process, there is what is called a resolution hearing, and that takes place within 15 days of the due process being filed. The resolution may take up to 30 days, and in the resolution, if there is not an agreement with both parties, then you proceed within that due process, and that is within the 45-day time period. And again, the decision-making lies within the hearing officer. Ellen, is there anything you would like to add on this piece?
Certainly, there's probably much I would like to add on a lot of these things. Just for time, this is a training that we could go into more in detail to each section, timelines and so forth. So, I think you did a great job explaining just kind of a jumping off point of how to understand what this particular process is. So
thank you, Ellen.
Yep.
So how and when to contact OPC. I have listed here our mailing address. So if you would like to send us, a request for assistance or anything, our mailing address is P.O. Box 512, Holdenville, Oklahoma, 74848. You may also call us. We always have someone Monday through Friday from 8 to 5 there to answer our calls. If you just have questions, if you need assistance, if you want to know about trainings or resources, we always have someone there 8 to 5. And if you do not receive someone because they're on the line, please leave a message and they'll return your call. We also have a fax. So if you would like to just fax us, a request for assistance, you may do that as well. 405-379-2106. And our phone number, I put the toll free out there. It's 877-553-4332. So we can help you understand your child's rights. We can help you navigate through your child's IEP. We have many trainings that are available. And we also have resources that on our website that you can go and search and look through, or you can just call us and we'll help you navigate and find whatever it is that you're looking for. Thank you for attending. I know this was a short training, and again, like Ellen said, we really could go into more detail about each of those, but we don't want to take up your time, and we wanted to just kind of give an overview of what this was on procedural safeguards. But we will like to do questions and answers, and I think Letitia might have a short survey for you.